Hey everybody, John Coggeshall here. Everybody calls me Cog, and I'd like you to listen to something. If a Virginia defendant had a number of gun charges for use of a firearm in committing a felony, if convicted, the court sentenced those gun charges consecutively to be served one after the other after the other. 4 or 5 gun charges, 5 years, 3 more years, 3 more years, 3 more years. That interpretation of the law resulted in many extreme sentences, sometimes more than 100 years in prison for one crime, even if no one was hurt or killed in that crime, but somebody had a gun or what looked like a gun. But in 2012, the Virginia Supreme Court, in Brown versus Commonwealth, finally decided that interpretation of the law regarding gun charges was just plain wrong. The court in Brown decided that multiple sentences imposed under Code Section 18.2-53.1 for gun charges may be run concurrently, meaning the sentencing court does not have to add them up one after another, and multiple gun charges sentences can now be served all at the same time. Unfortunately, that change of law made in Brown in 2012 came too late for many convicted defendants sentenced in Virginia courts, and many people, even juveniles, were handed down really harsh consecutive sentences and still face a long time in Virginia prisons for one crime with multiple gun charges, say holding a BB gun on several people standing together. Brown, though, could be a chance to go home for such excessively sentenced defendants by obtaining a conditional or partial pardon. In fact, a former Virginia governor, in at least one granted pardon, totally recognized such gun charge sentencing injustice made before Brown became law, and granted that inmate a conditional pardon and his release. I tip my hat to you, Governor. My brown hat. This is John Coggeshall. I'll see you again, and we'll talk about another interesting fact of Virginia law.